presented by the defendants in Jefferson Parish in the Supreme Court. What they said, and I'm going to quote how the Supreme Court described the argument there. They argued, and I quote, that the package does not involve a tying arrangement at all. They are merely providing a functional integrated package of services. And what did the Supreme Court say? They said, no, that doesn't work because, quote, our cases indicate that the answer to the question whether one or two products are involved turns not on the functional relation between them, but rather on the character of the demand for the two items. And Judge Oreck said, it says the same thing in Teradata. Our cases indicate that the answer to the question whether one or two products are involved turns not on the functional relation between the case that Mr. Doran referred to us earlier. The defendant there, SAP, said, well, we have an integrated software product. And the court said, well, I'm going to look and see if there is separate demand. The fact that you go ahead and you integrate these two things doesn't insulate you from review under the antitrust laws as to whether what you have done in integrating them is a tie. And here, the supposed integration is not a technical integration. It is a contractual tie of the two separate products. And so the thing the court needs to do is to look at whether there is separate demand. That is the right test. And it looked like Your Honor was going to say something, so I don't want to.
So Apple Pay seems to be, to me, much more like PayPal than than when I'm in an app and I purchase something and it's tied to my credit card. I don't see how that's. I don't see how the transaction of of divvying up the payment is a separate and distinct product.
So to address the first point, if I'm getting an Uber, right, my credit card is in there already, and I get my Uber, and it seamlessly goes through, and I don't have to do anything else. It's just like IAP in that respect, except Uber is not required to use Apple services. Why? Because Apple doesn't make it. We can speculate about why they have chosen or not chosen to extend the tie that far, but they have chosen not to. As to whether it's a separate product, this is something Dr. Evans does address, Your Honor. There is, in the first instance, a transaction between a consumer who is looking to obtain an app and the developer in the App Store, facilitated by Apple, to obtain the app and get it downloaded onto the device. That is a transaction that Apple facilitates through the store because Apple requires everyone to go through the store. Whether a year from now that person wants to upgrade their fitness app from the free version to the premium version and get more data about their daily run, or whether somebody wants to upgrade their subscription to a particular periodical or news source, that is a separate decision made at a separate point in time, which is a transaction that occurs between the user and the developer of the app. So to take Fortnite as an example, if a Fortnite player a year from now, after downloading the app onto, well, it can't right now on the iPhone, but after downloading the app onto his or her device, wants to make a purchase in the game, that is a relationship that the app has built with the consumer. It should be run by the app and the consumer, the customer service, the refunds. They should all be managed between the developer and the consumer instead of having Apple intermediate down the line in this entirely separate transaction.
All right, a response.
Your Honor, first of all, Jefferson Parish and Teradata both did deal with separate products and products that were offered separately. And here, IAP has never been offered separately. It's never stood alone as a product. It's never been offered as a product, and there's no evidence of a separate demand in the market for it. So it's utterly distinct from the tying of a second product. Was not a separate product, and that's exactly what we have here. And just as the court could find that on the motion to dismiss stage there, so too this court can conclude that this is not a separate product. We talk about, or Mr. Bornstein finished up by talking about the timing of the transactions, but Mr. Schmolensky addressed that directly in paragraph 6 and paragraph 59 of his declaration, where he said there's no economic basis to distinguish between in terms of evaluating whether something is a product, a separate product or not, from an initial transaction to a subsequent one. At the end of the day, Your Honor, I'll take no more time on this because this is simply an element of the App Store, which is an element of the iPhone. It's a fully integrated product. It is not a separate product with a separate demand in a separate market.
Okay.
Your Honor, may I be heard on the subject of separate demand, which has been raised a few times now?
All right, briefly.
Sure. I will just point out we have in our papers, I can refer the court to it, extensive evidence of separate demand for the payment processing checkout function from the App Store. There are, first of all, the apps that Apple doesn't require it to be used for, like Uber and other physical apps. There are the other app stores we've identified on Android, like Aptoid and SlideMe and others, and Epic Games itself that doesn't require the use of an affiliated IAP. Those are in footnote 45 of the reply declaration from Dr. Evans. There is evidence that when Epic did the hot fix, over 50% of people chose to use direct pay. There was user demand for that product, separate from Apple IAP. And Apple disclosed in its papers for the first time that there have been thousands of instances in which developers have attempted to introduce a separate payment processing service in an app, and Apple has rejected it. There's clearly demand from both developers and users for something separate here.
On that last point, separate from the antitrust specifically, you've mentioned, Mr. Doran, multiple times that, and it was my understanding that Apple uses third parties to address the payment function. One, am I correct in that? And two, does Apple use, or would they use other providers, let's say such as PayPal, if PayPal gave you your 30%?
No, Your Honor, because IAP involves a number of other elements. For example, IAP deals with foreign taxes, it deals with foreign withholdings for the developers. And as to the users, when a transaction goes through the App Store, then Apple's commitment to the safety, security, and privacy of its members kicks in. And for example, the payment information provided to Apple by users is never shared with the developer, and there are parental controls in place so that parents have an opportunity to make sure that their kids aren't buying too many skins or V-Bucks on Fortnite or whatever another parallel may be. It also facilitates family sharing of purchases. It facilitates the generation of historic records of purchases. So there are a lot of elements of it that are part and parcel and really integrated into the operation of the App Store. And so it's far more than just one small administrative step. There's a lot of code and a lot of functionality, but it's all, again, fully integrated into the App Store and has really been there since the beginning.
So your expert opines that there's no separate demand for IAP. But as Mr. Bornstein correctly points out, once in that short period of time between when Fortnite was taken off the Apple platform. And the dual functionality that had been placed on there by Fortnite was available. 50% of the people did, in fact, use the alternative mechanism. Doesn't that undercut, in fact, your argument that there is no demand?
No, Your Honor. What it seems to evidence is that when people can purchase V-Bucks for $7.99 instead of $9.99, half of them will elect to pay $7.99. I think what's probably most enlightening about that statistic is that half of the people prefer to stay within the App Store and within IAP because they trust Apple to protect their safety, security, and privacy.
Okay. It's the last topic that we haven't really talked about in terms of the Section 1 and Section 2 arguments. Mr. Bornstein raised it. I don't know if you want to raise it or not. Mr. Doran, is the rule of reason analysis that Apple identified in its brief.
Your Honor, I think the distinctions that Mr. Bornstein draws in order to avoid the holdings in Microsoft and then the further discussion in Qualcomm of the need to do a deep fact analysis and therefore that the per se standard really has no place when dealing with the tech platforms. The fact that there are contract provisions involved as well as integrated technical elements, we don't think changes the analysis. I think, frankly, the fact that one would need to sort out between what is the nature of the product, how integrated is it physically into the platform, is it in fact only a contractual limitation, or is it also a technological single product? If one were dealing with what is clearly two separate products, there may be a discussion to have here, but here there's a threshold question of whether or not there's just a single product. We believe that's not even a question. As Your Honor noted, it's really a clever argument to dispute the 30%. So this is clearly a rule of reason situation. Having said that, we also think that with Rick Mick, it shows that it's a situation that is easily resolved in finding that this is a single product that therefore cannot form the legal basis of a tying claim.
Okay. All right, let's go ahead and shift to the other elements. This portion of the argument, Ms. Forrest and Mr. Boutros, will be much shorter. Unlike junior people, I don't feel so bad given that you all get lots of time in front of courts, and so you don't need additional argument time. I always feel bad when I have a young person who is given the last motion to argue in front of the court, and I'm out of gas and just say, no, I'm not going to hear argument, and I feel bad about it. But with you two, I don't feel that bad. I actually didn't read all that much new in the additional papers with respect to the remaining elements. So that's why I said I don't know that this part of the argument will be that long at all, given my admonition to you in the beginning not to repeat. But there were a couple of new things, but really not much. Ms. Forrest.
Yeah, thank you, Your Honor. What I'd like to do is to focus on a few things that we did not point out in our papers that are uncontested by Apple in its papers as to the irreparable harm that is real, that is actual, and that is happening today. And these are things which were set out in the declarations, the opening declarations of our witnesses, and they were not contested by the Apple witnesses. So I think that it's important to point these things out. One is that the iOS business for Epic has been shuttered. and that there are all kinds of statistics in Mr. Sweeney's declaration as to the declines. That is real, and that is happening. In addition to that, we have a shuttered series of businesses that are event businesses. These are the events that Epic puts on through the Fortnite app for concerts that we know the iOS users want. There were 2 million of them who attended the Travis Scott concert in April of 2020. We know that there is iOS demand for the other concerts and events in terms of ESPN exclusive performances, for the Discovery Channel exclusive performances, for the social justice conversations. Those businesses have been entirely shuttered for Epic. In addition, and none of that is contested. There is no contest to the diminution of goodwill and to the reputational harm. No contest to that. There's also no contest to the damage that is flowing to the Unreal Engine. In fact, Apple actually concedes that the Unreal Engine is having an existential crisis, and it actually puts forward the Unity as an alternative development platform engine, acknowledging that the Unreal Engine is going through an existential moment. Having competition go from 2 development platforms with Unreal Engine and Unity down to 1 is not an answer. There is absolute irreparable harm to Epic's Unreal Engine business. It's got thousands, hundreds of thousands of developers who have millions of licensees who are dependent upon these engines, and this is going to shutter that business for Epic. That is not contested. It is also not contested that the other ways in which Apple is threatening now to extend its collective punishment through the withdrawal of tools and the ability with the development programs to allow the other Epic properties to function, that is also going to potentially shutter those iOS businesses for Epic. So there is an across the board amount of collective punishment against all of Epic's iOS businesses which have been shuttered, and where Apple is not contesting those facts. Your Honor, I'd also like to talk about one argument in this regard that Apple raises with respect to whether or not the preliminary injunction context is a context in which the case law, which suggests that the breach by Epic of its contractual relationship with Apple gives it the right not to have to deal any longer and to terminate at will its contracts, and whether or not it withdraws and impacts the equitable ability of this court to provide injunctive relief. A couple of points on that. What I'd like to say first, Your Honor, is the great irony that it would be if it in fact were the case that the same act that for the Supreme Court cannot be held as a basis for denying recovery at the end of a case could nevertheless allow for the complete destruction of a business during a case. It has got to be.
The argument with respect to that particular topic really does hinge on the fact that you succeed, right? And it goes back to the likelihood of success on the merits. So it's circular. You are irreparably harmed and cannot be damaged by being irreparably harmed because you're going to succeed, but you only succeed if. I mean, it's a circular argument. So it hinges on the first part of this debate.
It does, Your Honor. If Your Honor does not find a likelihood of success on the merits, then a PI will not issue here. That is certainly true. What I am suggesting is that to the extent that the balance of equity element has been argued by Apple to not apply to us, that we have no equities based upon our conduct, that is not what the Supreme Court case law holds. It's not what the principles of those cases hold.
Well, I certainly agree with you. I mean, I certainly agree, right? Balance of equity is one of the things that we look at, but it is a separate and distinct element from likelihood of success. And other than the fact of you arguing, and I still separate Unreal Engine and Fortnite and the other games. the argument with respect to Fortnite, your argument is really just we're going to win, and so therefore we get the balance of equities. It's nothing more than that.
Your Honor, it's also that there is extraordinary consumer harm that is happening right now, and
that's public interest. And again, you know, I don't conflate them. That is, I am required to do a separate analysis for each. And what happens with the public is separate and distinct than what happens with the parties. And those need to be evaluated separately.
I agree with you, Your Honor. And my point for the balance of the equities is that to the extent that you have an entity here, Epic, that is actually ceasing to comply with an anti-competitive provision, which we believe the certain provisions of the Apple contracts constitute, that those equities are in our favor, and that when consumers are harmed by the fact that there's retaliation for that lack of compliance with an anti-competitive provision, that those equities are also in our favor. I agree with you that the harm to the public actually hits on multiple factors, but it also hits on balance of the equities. I can, Your Honor, if you would like, for a moment, talk about Apple's arguments that there are security issues that somehow take away our arguments on the public interest.
I think that's a good argument to be had. I would just say, you know, there is some case law with respect to, well, first of all, I should back up and say, in general, we don't have federal courts issue injunctions just because parties get into a contractual dispute. And in many ways, part of this is all a contractual dispute over the licensing fees that Apple is engaging, in addition to the antitrust issues. But generally, we don't have federal courts do that. There are instances, though, where federal courts would have might issue orders to keep the status quo in situations where a company or business is going to go out of business. That's not the case for Epic. No one's entitled to make billions of dollars. There was a calculated decision here, and as the numbers went through these with Mr. Bornstein earlier, the iOS share of the pie for Epic is pretty small relative to everything else. So we aren't in a circumstance where some business is going to go out of business. Really, to the extent that there's harm, it's the public interest, which is different. So it was interesting to me, the declaration of Mr. Sweeney. Mr. Sweeney's declaration did not, in fact, indicate that there was nothing in the Unreal Engine that violated effectively paragraph 3 of the license agreement. What he said is that Epic doesn't engage in malware. Well, great to hear. Glad to hear. I don't think anybody, any reputable company should be engaging in malware. But he didn't go further to say that there is nothing in there that interferes with Apple software or services, that there's nothing in there that any hidden code that doesn't provide or unlock or have additional features, that there's nothing in there that is attempting to hide or misrepresent or obscure features or content. Why is that? And is there?
Well, Your Honor, there are a couple of facts about the Unreal Engine that make that argument that it could somehow act as a Trojan horse really a total straw man. Number one, the Unreal Engine is not consumer facing. This is a development platform on which app developers make their own apps. That's what this is. The app developers are the one who are making the apps that then go into the App Store. It's a development platform. It's not consumer facing. And that's set forth in the declaration of Mr. Grant. It also is with an app where there's a development platform where there's no IAP. This is a completely irrelevant argument to the Unreal Engine. The Unreal Engine is a development platform that is used by developers all over the world for all kinds of different industries, not just gaming, but it's used for electronics, it's used for medical devices, it's used for space, it's used for airplanes. And it's those developers who are determining what the functionality is. So the idea that it could act as some sort of Trojan horse to Apple is misapprehending the Unreal Engine from start to finish.
Yeah, I think, and let's see, Mr. Boutros, why don't you go? You can respond on this one. I'll come back to you, Ms. Forrest. But I think that Apple's, the sky is falling down approach on this topic is a bit overblown. I did find the fact that that Mr. Sweeney was a little bit obscure in his declaration to be interesting, but I also don't think that Apple's really on solid ground in some sense that that everything's going to explode because the Unreal Engine's allowed to operate.
Let me start with that, Your Honor. Thank you. First, as I think the court was alluding to this, put aside whether the Epic tries again to cheat and to sneak in a Trojan horse, which really went to the core foundation of its agreements with Apple, bypassing the app review process. Let's assume it doesn't try it again. But there's also the problem of inadvertent problems and things that they might do. And what they're trying to do here is go after the entire business model. If this court were to issue a preliminary injunction, Mr. Sweeney is trying to be the Pied Piper of other developers. He's trying to bring everybody along. And if this court were to say that others could do what Epic did here, which is cheat, breach its agreement, sneak in software to bypass app review and IAP, others would do it too. And that really goes to the core of the system. So it's not just Epic and Unreal Engine that we're concerned about. And that is a fundamental core of the business model. And Mr. Bornstein basically again admitted that Epic wants to take down and have this court at the beginning of the case issue an injunction that would go to the core of Apple's business model and unravel it and be a green light to other companies. And that would be very dangerous. We do take the security.
Let me ask them. If I leave in place, if I make the injunction, the temporary injunction pending trial, the same as the TRO, then the public knows, right, that you breach the agreement, it's fair game to kick you off the platform. And really, my sole focus with respect to the Unreal Engine has been that it was a separate contract, and the harm to the public was incredibly high, especially when there wasn't a breach of that particular contract. So doesn't that shield Apple in the way that it needs to be shielded for purposes of this short period going to trial?
Let me go right to that, Your Honor. First, as Mr. Schiller points out, and he was one of the founders of the App Store, it's extremely important for Apple to be able to terminate affiliates. And this is a practice. The court in its TRO order invited additional evidence on this point. And as he said, that even since 2016, Apple has terminated affiliates thousands of times to protect consumers and privacy and data security. And on this point, Your Honor, let me just go right to the new evidence on Unreal Engine, because I understood the court's concern there. First, we now know not some innocent party, as they told the court at the TRO stage. Paragraph 68 of Mr. Schiller's declaration states that, without dispute from Epic, that Epic International is siphoning off illicit payments from the overseas Fortnite users through the hotfix. So they're participating in the scheme, the cheating that happened. Secondly, Epic International, by doing that, itself is breaching its agreements. It's breaching, as the court knows, in the guidelines, which are incorporated into the developer license agreement, it precludes cheating the system and dishonest behavior. That's what Epic International is doing. It's profiting from the wrong. In addition, as Ms. Forrest alluded to and didn't dispute, we've shown that Epic International is controlled by Mr. Sweeney, Mr. Penwarden, who submitted a declaration saying he's basically in control of Unreal Engine, even though he's the chief engineer for Epic Games. Epic Games, in responding on the sign-in with Apple dispute, which is all the correspondence before the court, admitted that Epic Games and Epic International, Unreal Engine are all tied together, and Epic is managing that. And so it's a different record, Your Honor, and I think it goes to this retaliation point. Apple wasn't retaliating against Unreal Engine. It was doing what it has done thousands of times, was protecting its ecosystem. Yes, Your Honor.
I understand that, Mr. Boutros, but I can also say that every time Apple has a breach of contract with one of its developers, they don't haul you into court to defend them, right? This is no small case. And all the developers know that. This is not a small case. So if someone would dare to do what Epic has done, the likelihood that they are going to get shut down and shut down hard as a developer, as you say, your guidelines indicate, it's in there that the developer, not just the contract, but the developer can be shut out, seems to be a contractual right. But this is not an ordinary case. And I think you would probably agree with me that this is not the ordinary case. And so when we have extraordinary cases, judges try as best we can to keep the playing field as level as possible with as little harm as possible so that we can, in a objective way, move forward. Now, one of the things that occurred to me, having read that paragraph, and I would like a response on that topic, Ms. Forrest, is whether or not to order the payment of the 30% that is being collected by International, or has been collected by International, to Apple during the pendency. Thoughts?
Your Honor, I can let me respond to that question first, which is that if we lose this preliminary injunction in terms of IAP and are not able to have the Epic Pay be part of a Fortnite app that is available on the App Store, and Your Honor finds that, then putting the 30% that is coming in from the small number of Apple users who are still in existence, which is less than 25% of what they originally were, then that can go into escrow, can go wherever Your Honor directs. Yes. You tell us where to put it and it will be put there. And let me just also respond to the fact that Epic International has been receiving those payments. It's been receiving them simply as an administrative matter, only as to foreign transactions. It's not been receiving them as to all transactions. So the idea that it is somehow siphoning off illicit payments, I think, is using hyperbolic language to mischaracterize what is occurring here. In terms of the Epic International and in terms of all of the other affiliated companies with Epic, because it's not just Epic International, it's not just the Unreal Engine. We focus on those, but there are others, and those are set forth in Mr. Grant's declaration. And the facts as to those are not contested. They are not integrated agreements. They are not agreements that can be terminated at will. Certainly they cannot be terminated at will by a monopolist who has different kinds of law applicable to his or her or its conduct. They are entities which have got different start dates. They're entities that have different products. They're entities that have different team ideas.
I don't think what you've done, though, with respect to anything other than the Unreal Engine, is provide the same kind of compelling case with respect to the damage in terms of public interest.
Your Honor, you are correct that we did focus on the Unreal Engine because there's only so much that one can actually sort of evidence put into the record in this truncated proceeding. However, we do have evidence in the record relating to House Party, relating to a number of the other properties, including Life on Air, K-Raw, Psionics, and the Epic Sweden property. And those are all set forth in the grant declaration, paragraphs 5 through 12. So there is evidence that they will be impacted if the tools are taken away, the same tools and their program developer agreements are cut off, just as with Unreal Engine, they will be severely impacted. Those facts were in the opening declaration of Mr. Grant, and they were not contested by Apple. If I could, Your Honor, I could move on to a couple of other quick points that were raised by Mr. Boutros. One is the choice of the business model by Apple, and I would just suggest that a monopolist cannot choose a business model and stick by it without consequence when there are unlawful contractual provisions that are securing it.
Do you have a perspective yet as to what period in time, at what point in time did Apple become a monopolist?
Your Honor, I do know that as of 2018, when Epic itself went on to the iOS platform, that's the data that we have. Apple was already in a monopoly position. It required us to.
When you're claiming, other than you want me not to think about the gaming industry, and I think it's obvious that in 2007, nothing existed. And in the 2007, 2008 early years, Apple created something. And now it's a ubiquitous platform. So they've gone from being a non-player to an innovator. And at some point, there's a claim that they became a monopolist.
Well, Your Honor,
even though right, rates haven't changed. So do your experts have an opinion? Because we're supposed to, from your perspective, only be thinking about all the apps or the entire ecosystem. At what time, when did the shift happen? What happened?
Your Honor,
maybe you can't answer that question yet. I don't know, but it seems to me
I can answer part of it.
Question.
I can answer part of it, which is that there are companies which actually have innovative products and achieve a monopoly position, as we started off today, with business acumen and with innovation, that they don't unlawfully.
Excuse me, Your Honor. I'm sorry.
I thought so. I'll tell her. Thank you. Ms. Forrest, you need to slow down.
Oh, I'm sorry.
Our court reporter, you can't see her on the platform, or at least I can't see her on the platform, but I generally, we've been together for so many years. I know when cadence, when the caffeine kicks in.
That's the cry for help. I get it. Okay. Let me just say that there are instances where there is a company which has an innovative product where they have a monopoly position in that product almost immediately. However, they don't have an unlawful monopoly. The unlawful monopoly comes along when there's monopoly maintenance conduct. What we have here and what we know we have here from Apple as of the time that we entered into our contractual agreements, which were contracts of adhesion, there was no
and that's okay with you, right? You're not opposed to contracts of adhesion because you generate them, right?
Well, the Unreal Engine, for instance, actually has negotiated
contracts. Seriously, Epic Games is not opposed to contracts of adhesion, are they?
There are certain contracts of adhesion that Epic Games has, correct.
Okay, go ahead.
What I'm suggesting is that as of 2018, when we entered into our relationship with iOS, there were no alternative app stores. And there was no alternative to IAP. It was a monopolist at that time, and it has sought to maintain its monopoly throughout that time. You look like you're about to say something, so I don't want to interrupt.
Go ahead.
Okay. So that, I think, is our view as to when did it start? It started at the beginning. When did it become unlawful? That becomes a more complicated question. It became unlawful as to us as of 2018. When did it become unlawful to the point where we could no longer actually abide by the contractual provisions? It was after our ability to even try to negotiate with Apple, which we did. We did try, ran out. And only after that, in the summer of 2020, did we sue. And if I could, Your Honor, I'd go through just a couple of the other points that were raised by Mr. Boutros, which is that he said that we had been a cheater and that this was an act of sabotage. And I want to address that because that goes to both the public interest and the equitable arguments that have been made, as well as whether or not the court would feel persuaded by the irreparable harm. We are not cheaters. We are not saboteurs. There is uncontradicted evidence in the record that was put in the opening declaration of Mr. Grant and Mr. Sweeney relating to the turning on of the payment service. We call this the hot fix. And the word hot fix seems to have this negative connotation, but let me just say a couple of words about it.
I don't know that it has a negative connotation. You were not forthright. You weren't. You were told you couldn't do it, and you did. You know, there's that old saying, a rose by any other name is still a rose. I mean, you can try all you want. You can try, but you're not going to convince anybody that you had something in there. You tried to have Apple approve of it, good or bad. They said no, and you did it yourself. It's self-help.
What I want to say, though, is that we have used hotfix hundreds of times in the past.
Lots of people use hotfixes. That's not the issue. That's not the issue. The issue is that you were told and you knew explicitly because of your contractual relations that you could not have that, and you did.
My point is
really pretty simple.
I understand, Your Honor. My point is I want to connect that to the alleged security issues, because Apple ties the hot fix to sabotage as if it's tied to security. Once it's understood that hot fixes are commonplace, that they were used hundreds of times in the past, that Apple never complained, they're not a security issue. And indeed, no security.
What the security issue is that you did something, you lied about it by omission, by not being forthcoming. That's the security issue. That's the security issue.
Your
now,
Honor,
it could have been, you know, as you say, it's not malware. But let's not debate a point that, I mean, to tell, you know, there are plenty of people in the public who consider you guys heroes for what you did, but it's still not honest.
Your Honor, what Apple tries to do is it tries to tie the hot fix to the idea that we have made the ecosystem insecure. After a full month with this code, they know that there is absolutely no security or privacy issue that is real.
Where did I start this discussion? I told Mr. Boutros I thought that they were really overblowing their claims. So yeah, no argument there. But don't try to convince me that you were forthright when you weren't.
I understand your position, Your Honor. And I do know that Your Honor has also read our papers thoroughly on this point, so I'll leave it. Can I talk just a little bit about the security point, or have you heard enough on that as well?
No, I don't think there are particular security issues. Mr. Boutros.
Yes, thank you, Your Honor. If I could just back up for a second in terms of the preliminary injunction standard. I think the court was just getting to a point I was going to get to. Epic wasn't honest. This court's sitting as a court of equity. There's no dispute that Epic needs to meet all 4 preliminary injunction standards to get an injunction, a preliminary injunction. Ms. Forrest just admitted they must show likelihood of success on the merits. The Garcia v. Google en banc decision says that they must meet that standard. They haven't met it. As Mr. Doran demonstrated, and the court mentioned the Wild West, this is the frontier fringes of antitrust law. They can't possibly show likelihood of success. Epic needs to also show irreparable harm to itself before we get to public interest or balance of the equities. It has failed to do so, both as to Fortnite, for the reasons the court held in the TRO, self-inflicted wound, a problem of its own making. They could have just kept performing. They just wanted to get more money and get the platform for free.
Are you repeating yourself? Anything new?
Yes, let me just make the new part, Your Honor, that on the public interest focus, it's Epic that's injuring the public interest with respect to Unreal Engine and third parties. Epic is by not complying with the contract. It's Epic that triggered the contractual rights, and they could fix that with a keystroke. So when you look at all of the factors, they must meet them all.
At this point, are you telling me, I understood that Apple had said, and it really could be just hypothetical, because I don't think that they would agree to go back on, but Apple said, look, even if you agreed, we're keeping you off for a year, period. Has their position changed?
Yes, Your Honor. The standard language from the usual letter in this context was included in the Unreal Engine letter, but Apple's willing to, since this court is involved in the court supervision, if Epic would just come into compliance, it can free Fortnite, it can free Unreal Engine by just complying, paying what it owes, and we have a trial and summary judgment and proceed. And that will protect the public.
What about this? What if that 30%, well, I was going to say, what if it went into some escrow account?
That would at least address.
It's kind of, we're talking about billion-dollar companies. I don't know why we would do that, but other than to give each side maybe a little bit to hang their hat on. So what if I said that?
Well, Your Honor,
escrow account.
Yeah, that at least addresses part of it. It's the fact that Epic International is part of the scheme to take these profits and take it all. But there's also the 30% that Epic is taking now. It's Epic Games is taking as well for U.S. sales. But it really goes to this point, Your Honor, just as a legal matter. The same rationale with respect to Fortnite applies to Unreal Engine. Epic can cure it in a second. Just go into compliance. If it's not about the money, pay Apple the money they owe Apple. And then Unreal Engine, Apple's willing to let Unreal Engine and Fortnite back on the system. That's the proper approach here. And what I would suggest to Ms. Forrest. Oh, yes, Your Honor.
But respond to my question. If will Apple let Fortnite back on, and would Ms. Forrest, Epic Games, agree to go back on without their own payment option, but all monies that flow from that go into a escrow account pending resolution of this lawsuit? Yes or no? Or you don't know? Mr. Boutros?
So if I'm understanding, yes, Your Honor, if I'm understanding the court's question, if Epic were to disable the hotfix, their own payment system, go back to using IAP, the 30% were to go into some sort of escrow account, and Unreal Engine likewise would come back on. That would address a lot of the issues. I would have to ask my client about it, since it is a significant thing, but it does at least start to address the issues. There's just no way we can have Fortnite stay on the App Store, defying IAP, defying app review, for the reasons the court already had ruled. And with respect to Unreal Engine, it seems like it's easily fixable by Epic.
Ms. Forrest?
Your Honor, we would not agree that a scenario under which we are required not to have consumer choice and competition on payment options. I don't need a long answer.
Yes, so it sounds like no, you're not interested in that.
We're not interested, and we would also say, Your Honor, just briefly, that the cases that we've cited, the Supreme Court cases, say that this court should not give its assistance to unlawful provisions by monopolists, and that therefore we would be agreeing and trying to comply with unlawful provision.
Yeah, I didn't buy that argument before. I'm not particularly impressed with it now. All right.
Can I say a couple of things just in response to things Mr. Boutros had said earlier?
Briefly.
Okay. I'll try not to be too quick. One, that there is irreparable harm to Epic. Epic's iOS business has been shuttered. And two, monopolists, when they say that
there's no case law that says that, my $1 billion company is is losing some millions, and so therefore that's irreparable harm. There's no case law to support that.
No, there's lots of case law that says that when you've got a diminution in goodwill, which is exactly the destruction of a business, that is precisely the time that there should be a preliminary injunction that is entered. It doesn't have to be all aspects of a business. It is this business.
Your goodwill is probably in some ways increased. So again, maybe for some people less goodwill, but for other people, lots of goodwill. And it certainly, and your marketing campaign has been lauded, given your conduct. Okay, what else?
Your Honor, if I could just address one more point on the Unreal Engine. I don't know if I misheard Ms. Forrest suggest this, that somehow it's been destroyed or it's going under. The evidence, they had the burden to bring evidence. Mr. Penwarden talks about a few dozen complaints or concerns, gives 3 or 4 examples. And I just would suggest it's a extreme form of relief they're asking, having breached the agreements. They could cure the problem themselves. They didn't bring forth evidence of the kind of harm they're suggesting to the public and to third parties, and they could cure it themselves. And Your Honor, I understand the court's sensitivities about affecting other people, but I'll end with this. It's the same analysis as to Fortnite. They could fix it in a second. They're not claiming damages. They have publicized their campaign. If anyone's getting wind of what's happening, it's because they've been on this blistering ad campaign, and they formed a group last week of other developers to expand it. So they don't need this court's emergency help. They have the keys in their pocket to free Fortnite and Unreal Engine. Thank you.
Your Honor, on Unreal Engine, let me just say, because I think the evidence has been completely mischaracterized, there is unrebutted evidence in the record in both the declarations of Mr. Penwarden and Mr. Grant that there are hundreds of thousands of developers whose platforms are at risk. We say that Apple, we believe, will stop accepting Unreal Engine apps that are built on that platform as of 2021. They will be then destroyed. We have numerous, dozens and dozens, and that's set forth in the Penwarden Declaration of instances where developers are saying that they are concerned, and we have millions of users who are reliant upon those applications. All of that evidence is in the record. This is not a handful of 3 or 4 examples. We have got millions of people who will be directly affected. Can I say one more thing on the...
Let me just say on that last piece. That if... it is not uncommon, as you all will know, that if circumstances significantly change, that motions and requests can't be renewed. All right, last issue. You said you wanted to say something else, Ms. Forrest.
The last thing I would say, Your Honor, is there's been discussion of a publicity campaign. All I would say with that is when you are taking on the biggest company in the world, and you're taking it on where you know it's going to retaliate, you don't lie down in the street and die. You plan very carefully on how you're going to respond, and you try water. And that's what we've done here. Yes, there's been a publicity campaign. We took on the biggest company in the world that is fighting us hard, and we knew that.
Your Honor, may I address that just briefly?
There are other people who are taking it on. And one of the questions that you never answered after our last hearing is what happened that made this so urgent. The topic related to the App Store is not a new topic. I tried a case over the alleged monopoly that Apple had with respect to iPods. It was so old by the time I got it. It was so old by the time we tried it that we had to bring iPods into the courtroom because no one knew what they were. And in fact, I'd forgotten you have to put headphones in. I tapped the little button expecting to hear the music and nothing came out. Until then I remembered, oh, you need headphones for these things. So we tried that case. And Apple won on the security issues in front of a jury. So this isn't just some judge. This was a jury who made that call. Um, and there is active litigation happening in the Cameron case and in the Pepper case on this topic. So, the Epic can choose to go out on its own, that's fine. But it's not as if others aren't taking Apple on.
I understand. Can I just address the idea of why did we do it? And just very, very briefly, we have heard in this case and in the Apple's papers that there is no separate market for the App Store and IAP. If we had brought a declaratory judgment argument that said that there were separate products and they were tied together, what you would hear from Apple is that they are integrated, that there is no separate demand. What we did when we released the hotfix is we showed that there was separate demand. We did proof of concept. We eliminated Apple's ability to say that there is no separate product. We showed that there is. That gives us something that we would otherwise have been unable to have. We had it for 6 hours, but by golly, those were an important 6 hours. We showed that consumers want the choice, that they want lower prices. We did the hotfix because we had to.
It's good evidence, but it doesn't mean that you can't go back into compliance. I mean, you can. And, which brings me to another point, which is that I think personally this case should be tried to a jury. And I want everybody to think about that. And the reason I say that is because individual judges don't have and aren't the be all and end all. I can tell you that circuit court judges don't give district court judges lots of discretion when it comes to factual matters, despite what it is they're supposed to do. They actually don't care very much. They're going to decide what they want to decide. I think we've seen time and time again, district court judges can we can write orders that are hundreds of pages long with all sorts of factual findings, and the appellate courts are going to do what they want to do. But when it comes to juries, they are much less likely to ignore the factual findings of jurors. And you're going to go through this whole process. It's going to cost a lot of money, time, and effort. And as we've noted, these are important cases and they're on the frontier of antitrust law. You might as well find out what people really think and want and take that to the Court of Appeal. Because I know that I'm just a stepping stone for all of you. Whoever loses is going to take it up and say everything I did was wrong. That's what litigators do. I understand it. There's no hard feelings. That's the job. But I think that it is important enough to understand what real people think. Do these security issues concern people or not? Is the concerns of the developers incredibly important? I think many people would think that it is. But I'll have you chew on that because I do think that this is something for which jury insights would be important. Otherwise, it's just one more judge. Okay, so with that, let's talk about trial schedule. Federal judges, in case you didn't notice, are a little bit busy. I don't want to try two cases. The difference between 6 months and 8 months and 10 months in our life is not a big difference. So I'm inclined to try both cases at once. So you should plan on that.
Your Honor, may I say one thing just to make sure that when we talked earlier about the no amendments to the pleadings that we didn't lose sight of one thing, which is our answer is due tomorrow. We are answering the counterclaims in order to make sure that that Apple understands exactly what our defenses are. However, we are going to move to dismiss under 12C 2 of the counterclaims that actually try to, or 3 of them that actually try to expand the evidence beyond really a breach of contract. We actually don't disagree that we have breached a contract if you find against us on the antitrust claims. That's not going to be an issue that's going to require a lot of a complexity in this case. If we are wrong, then we have breached the contract. And so we will try to get rid of, we believe we've got very good legal reasons to get rid of the conversion claim, the prospective economic advantage, and the separate covenant of good faith and fair dealing.
So I think it's a good motion with respect to conversion. And frankly, what I'd like to do is I would like for you all perhaps to meet and confer. You can file it tomorrow. Your deadline's tomorrow. It's probably already written. But perhaps after it's filed, you all can meet and confer. California law is pretty clear that in a conversion claim, especially when you're talking about money damages, you have to be able to trace the money. So if someone has, in the old days, a set of gold coins, you could have a conversion claim. But you really have, and I've actually written on this, you have to be able to trace. You cannot bring a conversion claim in your run-of-the-mill contract dispute. So you really should be able to address that without motion practice. And if you don't, is fine. I'll probably cut and paste from a prior order and dismiss it. You'd have to have some very good arguments to claim that somehow you've got conversion here. I don't know what the arguments are for trying to dismiss the implied covenant of good faith and fair dealing. There's always an implied covenant of good faith and fair dealing. So what would be the basis for moving to dismiss that claim?
Because, Your Honor, it's not a separate claim from a breach of contract claim. If there is a contractual obligation directly on point, then one does not have a separate breach of covenant in good faith and fair dealing.
Under California law, you can plead in the alternative. We let people do it all the time.
They're not asking for an alternative reading, Your Honor. They're saying that there's a direct contractual provision that has been breached, and then they're also asking for a breach of covenant of good faith and fair dealing. That's simply to bring in intent. There's no reason to bring in intent. We're conceding that if we're wrong about the antitrust claim, there's been a breach of contract. We're conceding that. This is not a situation.
I'm sorry, Your Honor. Excuse me. This is Renee Mercado.
I'm sorry.
Counsel needs to slow down.
Let me repeat. I apologize, Ms. Mercado. That when there is a contractual obligation that is directly on point, then there is no separate covenant of good faith and fair dealing claim that lies. And we believe that is exactly on point here, and that it's only being asserted in order to bring in additional evidence of intent. This is a simple contract issue. It's the opposite of the antitrust. If we lose on the antitrust, they win on the contract. It's not really going to be and shouldn't be a complex second trial. In terms of prospective interference with prospective business relations, again, when there are contractual obligations directly on point, that doctrine is inapplicable, and there's good California law on that as well.
Mr. Dorn.
Your Honor, obviously we disagree. We have pled the claims in the alternative, as is our right. And obviously we'll look to see what their motion has to say, but we disagree with that characterization of the law and with our rights as the cross complainant. We believe that the claim should stand.
Well, I suspect that you'll follow your motion. 35 days notice is a standard. Don't expect oral argument, and I'll probably just issue an order. I mean, and you certainly should not stop. That is, you need to get going here because time is going to be short and of the essence. All right. So with respect to the schedules that have been proffered, thoughts?
Your Honor.
If you want to say something other than what's in your papers.
Your Honor, what we would just urge the court is for the shortest schedule possible, particularly if there's not going to be any injunctive relief on one of our bases or either of the bases, whatever Your Honor decides, then it's going to be particularly important that we get to trial as quickly as possible.
I agree. And just so that you all know, I frequently set trials where there is an injunction in 6 months. So your stats are interesting, but they're not my practice.
Your Honor, I'm sorry. I thought Ms. Forrest had frozen, so I was remaining silent for a moment. Can I address the scheduling issue for just a few seconds?
You may.
Thank you, Your Honor. As you can see from Apple's schedule and Epic's schedule, both parties recognize that completion of document or data production in early January is I think we hope a reasonable goal. Get that done right by the time the holidays close out, and then turn to depositions and expert work. The toggles, if you will, in the schedule, I think Epic proposes that all depositions take place between January 4th and February 5th, whereas we would extend that by about 3 more weeks. Epic has told us that they intend to take at least the 10 depositions permitted under the rules. Obviously, as well, Your Honor, there will be third-party discovery, and that will involve, scheduling with third parties as well as getting their compliance with discovery obligations. So having documents produced by early January, followed by what we have is about 7 weeks of deposition discovery, to us seems like the practical and realistic approach, and one that can actually be achieved, and that we will not be back to the court asking for further relief on the schedule. So that was the thinking in the schedule that Apple's put forward. And then the other, I think, flex points in the schedule, if you will, are the timing of the expert reports vis-a-vis dispositive motions. Apple's schedule has dispositive motions after the expert report process is completed, if you will, and Epic's, they call it their compromise schedule. Epic's schedule has dispositive motions after the opening expert reports have been filed, but before the rebuttal experts.
Your Honor, may I just respond to a couple of things there? Mm-hmm. All right, thank you. I would just point out that in our 6-month schedule, which is a schedule that anticipates that there would be a trial, probably, I don't know what Your Honor's practices will be or the courts will be in terms of impaneling a jury, but that it allows a trial in the absence of a jury. It also, because it would be a bench trial, does not have dispositive motions, and so that is not built into the schedule. If we build dispositive motions into the schedule, what we did on the 8-month schedule is allow the initial expert reports to come in on February 19th prior to the initial dispositive motion being filed, and we followed then exactly the same time frames that Apple had in its papers for dispositive motions. So the difference is whether or not we're going to have more than just the opening of the expert reports for the dispositive motions. Again, we don't think that right now, we would like to have it tried by the bench in particular also because not only is it an equitable claim, but because of COVID and the uncertainty of when we're going to get a jury and the concern that might be some time. But that will take.
Judge Freeman is picking a jury in a Cisco case for next month. We are trying hard to pick juries here. You are right. We don't know what's going to happen. But we are trying. Okay. At least there are some things that you all agree on, so I'll order them. Last day to meet and confer regarding initial disclosures, October 5th. Complete your initial disclosures or state your objections by October 12th. Complete document production and data, you couldn't agree, so I'll give you January 6th, 2021. Do not intend to bifurcate. So I do need to know from Apple. I'll give you until close of business tomorrow, Mr. Doran, to let me know whether or not you're demanding a jury, or either one of you, frankly, given the counterclaims. Ms. Forrest? In general, and maybe I'll put it in the order, any deadlines I give, they're always Pacific time. Okay, so to the extent it's not obvious, I'll make it obvious, Pacific time. Close of business. I know for lawyers it's midnight, for the courts, we'll say it's 5 o'clock, even though we all know it's not, at least not for the judges and the law clerks. All right, that's what I mean by close of business.
Thank you.
Once I receive those submissions, I will give you your schedule. Anything else you want me to consider?
No, Your Honor.
No, Your Honor, thank you.
You should know that I have a major class action that is being tried in June. So June is probably out. I think you're looking at a July trial date. As soon as I finish that case, I'll do this one. But that case is old. It's gone up to the Court of Appeal and back down, and I'm not bumping it for this case. Okay. Anything else you want to discuss?
No, Your Honor. Thank you.
Thank you, Your Honor.
Case management conference, or once you get your schedule, you're good to go.
Your Honor, if you're asking if it'd be helpful to have a case management conference set, perhaps it would. And then after we see the schedule, if the parties agree it's not necessary, we can let the court know.
All right, that's fine. Does that work for you, Ms. Forrest?
It works. It works for me. I mean, we're fine getting it just with the court order, but we're also fine to convene a conference.
All right. Why don't we say, and you can let me know that there's no need. Should be fine. I'll put you on October 19th at 1:30 for case management conference.
And Your Honor, just to be absolutely clear, so there's no debate about it, we assume that as of now, we should be absolutely sort of full steam ahead to get everything done for document production, not waiting for the case management conference for that purpose.
I think if you don't want to fall behind, you better start now.
Thank you.
So, okay. Any other questions?
No, Your Honor.
All right, then. Everybody stay safe. I'll take it under submission. You'll hear from me in writing. Thank you.
Thank you.
Thank you, Your
Thank you, Your Honor.
The recording has stopped.